Mr. Baskin.
Well, thank you for having me back to talk about this important issue on behalf of Associated Builders and Contractors. And I'm also not going to repeat what you've heard from a number of witnesses already, except to say that this is one of the most burdensome and one-sided proposals of the many burdensome and one-sided proposals that you are considering and have been considering over the past 2 days. And on behalf of ABC, we object strongly to both the shortening of the time for employers to issue the voter eligibility list and the added burden and invasion of employee privacy of the newly required, deeply personal information you want employers to include for the first time. But the construction industry has a special concern, which is really the focus of my testimony today, because construction is unique. We have the Steiny-Daniel formula to deal with, unlike other industries in which the contractors are supposed to provide a list not only of the people who are working for them at the time of the petition, but everyone who's worked for them 30 days in the past year, 45 days over the past 2 years. And having worked with contractors, first, many don't have electronic record keeping. That may seem strange to some. Many are quite sophisticated and have all kinds of electronic record keeping, but none of them seem to have the Excelsior button in their payroll system. It doesn't just spit out these kind of records. And in fact, elections I've had using the Excelsior list in the industry, I can't recall one where they provided it to me to provide to the board early. The full 7 days seem to be needed. Now we're telling them that they have to do it in 2 days, which is clearly going to not be easy to put together, adds a new burden to them, and for what reason other than to speed up the process and give the unions more information faster and make for faster elections, which should not be an end in itself. And so that's really our concern about it. We certainly also object to the notion that it should be provided in advance of the petition, which we heard in some respects yesterday and today. That's in a way worse. Don't even know who the eligible voters are in that situation. It's also a problem. We heard some of this earlier about the problem with omissions and inaccuracies on the list. By forcing them to put it together faster and really in great haste, you're increasing the chances that they're going to make mistakes and omit people. And there's a case, 2012 automatic, the automatic case is the only name I have for it, which was a automatic fire systems construction contractor who left some names off the list, a small number of names. The union, they went through the election, the union had not gotten a single vote, but the board threw out the election because a few names were left off the list. That kind of thing is bound to happen more often with this sort of speeded up process in the construction industry in particular. We think it's just grossly unfair of the board to put that kind of time pressure on employers that you're proposing here and then punishing them for the errors that are caused by, with respect to your unreasonable deadlines. And so it's no wonder that many employers, and certainly in the construction industry, are outraged by this proposal. I think there were 9 times as many opposition comments filed by individual contractors this time as opposed to last time, even though they were told that the comments they've already filed still count. We've also, there were a few other points that were brought up that I do want to respond to. There was the question about abuse by unions of this information, that we shouldn't worry about it. I want to mention another case that was not mentioned earlier, the Pulte Homes case against the laborers union, in which the union hacked into and assaulted the company's email system as well as home email systems. The Computer Fraud Act was brought up. A company filed a lawsuit. They were not able to get an injunction, even though the court did say that they had shown a violation. Very serious issues that had arisen and really should not be countenanced. We also have heard, I think what it really boils down to is that there's the notion that the employers should be at the ready to turn themselves upside down over this type of thing, and that it's just another cost of doing business. But that's what the board said in the notice poster case, really. It seemed like a minor thing to folks on the board, and I'm not speaking to all of you personally, most of you were not present. But it really affected the business community, and they came back strong and went to court because it was yet another intrusion of the government into the workplace that had no justification. It was not necessary, it was not supported. And I've said my piece, and I'll be happy to answer any questions.
Now, wasn't that automatic fire system a case dealing with the employer unilaterally omitting names after those names were in existence on another list?
Yes, it was an omission as opposed to an error, but of course both are subject to the same general standard. They cited cases involving errors. Certainly, I would expect that the board hasn't said what it's going to do. If you're going to do something like this, you certainly should be modifying or making clear what's going to happen with the increased likelihood of errors, though the correct answer is don't do it at all.
Okay, but you would say that if we did do it, we should be sensitive to errors.
Yes.
Okay.
Absolutely.
Do you have a problem with the job classification piece?
Yes.
Why specifically?
Glad you brought that up, because in the construction industry, people change jobs all the time, even within a day. They change jobs, they change job sites. The type of work that they're doing makes it even more challenging to identify, certainly more likely that there are going to be errors.
With respect to the Stoney-Daniel formula, if a petition is filed in a situation where they're seeking a 9A certification as opposed to an 8F, and the employer decides that they want to campaign, they're going to have to utilize the formula to find the people anyway, don't they?
Not necessarily, and if the petition is filed, eventually there's going to have to be an eligibility list created. We're talking about the board's rule to accelerate the list. Yes, a list will have to be created. We're not asking you, although we wouldn't object to your revisiting the Stoney-Daniel formula, but assuming that's settled, that's what the contractors have to deal with. So yes, they would have to do it anyway, but they don't have to do it before the petition, and they don't have to do it within 2 days after a decision. So that's what your proposed rule is changing, and that's what we object to.
Okay.
All right.
Thank you.